The defense had every fact they wanted. Client biked home 20 miles after he was hit by a car on his bike. He raced 4 days later. He competed in over 200 races over 5 years. The defense 998 offer was 100 grand. The verdict, $3.249 million. Why is this? It's the thing I want to tell everyone over and over again. Most lawyers don't realize that facts are not stories. Facts don't tell stories. Stories organize facts. If you master this, it is something that will change every case you do forever. Every bad fact is just a good story waiting for the right lawyer. Welcome to TBI Lawyer Secrets. I'm Taylor Ernst, 2024 California Lawyer Attorney of the Year. I've educated over 20,000 lawyers and doctors, won a $63 million verdict, and authored the book, The Ernst Way, which is the definitive guide to TBI litigation. It's only by invite only, but it's going to be releasing to the public hopefully soon. So here's the catastrophic belief that's costing you millions of dollars. Lawyers think facts equal verdicts, and they do, but only in the story that's told. You see the client biked home and think, I'm screwed. I know this because this case was referred to us where the original offer to settle a car versus bike case was 14 grand. The reason was this is even with he biked 20 miles home, he didn't even have a TBI diagnosis for almost 3 years. And the lawyers on the defense just looked at this case and went, I don't know why they're trying it. Looks like a home run for the defense. And the reason is the facts were neutral the way they viewed them. They never looked at the facts as a data point that might be organized into a deeper meaning. The accident happened. That's a fact. What it means, that's a story. Whoever tells a better story owns the verdict because the jury wants to understand the meaning behind why they're there, the meaning behind what they're doing. The defense sees 200 races and tells the story, he's fine. We see 200 races and tell the story, he's desperately trying to hold on to the one thing that made him feel normal before the collision. And you can tell what one has emotional weight. It's the same facts, opposite meaning. The defense lost because they thought the facts told the story for them. They repeated 200 races over and over again. And then when we talked to the jury at the end, they said, I don't know why the defense kept talking about the 200 races. Like, it was clear he could still ride a bike, but there are other parts of his life from his brain injury that were fundamentally different. They never saw our story coming because they didn't know the story of why our client biked was the difference between the 100 grand offer and the $3.249 million verdict. So what am I doing? I want to tell you the story framework that we use, that I use, that just worked. So step one is you identify what the defense story is. What's their one-dimensional read? What are they going to stand up and say over and over and over again? And their story, as simple as it was the client biked home equals not hurt. Return to work equals recovered. Competed in athletics means physically fine. There was no attempt to find out what we were going to do with that. So that's step one. Step two is you find the human truth of why do people really believe these things? They bike home because they're in shock. They can't process what's happened. They're making bad judgments. Or how about the fact that you're on your bike? How else are you going to get home? Maybe you're going to call an Uber, get an ambulance. He didn't have health insurance. He was worried about that. Became a fight that we had with motions in limine. What would make me push through even with pain and the situation? Would it be pride, denial, fear, worrying that one of the things I love is going to be taken away? And the last thing is step three, is you order the facts and the suffering of the client into evidence of struggle. It isn't that he continued to bike in the exact same way. It's he continued to bike because he viewed the accident as something that tried to take away a lot of things from him. And it was the one thing that he clung to is, I'm not going to let this accident take away biking also. So when you have those facts, so step 1, 2, 3, but step 4 is in mini opening, you put out the facts early. You tell the jury, the defense is going to say he raced 4 days later. He competed over 200 times. He competed 3 weeks ago before this trial started. The defense will tell you this means fine, but we are going to let the medical evidence show you what this really means. And it creates that open loop hook of the jury wanting to find out the truth, where we're not taking a 2x4 and hitting them with the truth and saying, this is what it means. We're trying to say, hey, we're going to give you the facts and let you figure out what it means yourself. You get to choose what all these facts mean after hearing from all the experts. So, more war stories. This was Van Nuys, day one, trial was starting. We knew we had to deal with these bad facts. And one of the things that was crucial for our trial team, there's 3 people, myself, Nigel Whitehead, Danielle Miller. We're showing up ready for trial. We think we're going to get bumped again. And we get asked to go down the hall to a new judge who his clerk comes out. And 15 minutes before the judge even gets on the bench at 8:50, they hand us all the rulings on the motions in limine. The judge comes, sits down on the bench at 9 o'clock. We think we're going to be arguing motions in limine, and he says, the jury's going to be here in 15 minutes. I think we'll be opening this afternoon, meaning all of these bad facts, all the mini opening, all the stuff is go time in the next hour or two. So we'd been planning this for a while, and so we had consistently been asking, what do these bad facts mean? What can these bad facts mean? So when the judge handed us the motion limine rulings and was saying these races are coming in, defense counsel's excited. They know they're going to be able to put videos on. They know they're going to be able to cross on all this stuff. They get to do the standard story. And as much as it, you never want to lose motions in limine, but we had a plan even if we did. And so the mini opening, we stood up and talked about the 200 races, the 4 days later. We owned those facts as soon as we could so that we could put them into context immediately, where the jury's starting to think, well, what is it that this lawyer is going to be able to explain these facts? Because they're curious. And once they are curious, they really want to get to the bottom of it. So how do we set it up? We get to the end of the case and they still think these facts mean they win. And I want to give you one of the tools that we use. And we basically, you take the worst fact and you wonder, how can you make it your best fact? And so you can almost make a grid. We use a whiteboard tool to do some of this, but basically we take the 5 main things the defense is going to talk about over and over again, and then we list those, and then we list the defense story for each and what the defense story is really trying to teach the jury. You want to understand what the defense story is going to be, and the biking, what it is really saying is he's biking and therefore he doesn't have a brain injury. And when you list what the defense is doing, why they're doing it, and what they're trying to teach the jury, you find out that there's space between what the defense thinks it means and what it actually means, so that you can start drafting alternative meanings to the facts and look for those stories with your client. And so one of the things that we ended up doing is we waited till closing before we dropped the bomb on them. We got the defense experts to say there was no damage to the cerebellum. It's the back part of the brain. And we waited till closing, and we stood up in the first part of closing and said, the brain damage of the client who bikes is the frontal lobe and the parietal lobe. There's been no testimony this entire case that anything will prevent someone from riding a bike. Even the defense expert said the cerebellum was fine. And what the issue is for bike riding, it is the cerebellum. There's not been one piece of evidence that has listed bike riding as something you can't do this whole trial. And therefore, why are we talking about it? And it creates an enormous information gap that the defense then can't deal with because there's no more evidence coming in. And so what originally seems like a story that cannot be overcome at all, you see the 200 bike races and you think case over. He biked home, he raced 4 days later. It's now in context. Facts are neutral. They're always neutral. Every fact is just a data point that you have to put all the data points together to make the story that makes the most sense to the jury. So again, the defense story, 200 races, think he's fine. We see the 200 races and he is desperately trying to hold on to the person he used to be. It's the same facts and it's the opposite meaning, where the idea of someone fighting through their injury, where he has problems with memory, he probably shouldn't be driving, he leaves the door open at night, he forgets to eat dinner, his wife is a UCLA nurse. You start hearing a different story and it becomes someone you want to fight for. So this isn't just messing around with wordplay. This is the difference between what the defense thought the story was because they never really looked at it, and what the story actually was, that the jury, even in deliberation, there was a handful of jurors that wanted to give more. So, breaking it down again, the story framework. You identify the defense story. What's their one-dimensional read? Step two, you find the real truth from your client. You can talk to them. You can talk to their friends and family and all the people that have seen them. Why are they actually doing the thing that the defense says they mean something else? And you find out what the truth is. And like, what would be the reason that you do the same thing? Pride, denial, fear, legacy? Step three, you give additional information that makes the defense cursory read, like the surface read, not make sense anymore. You give that additional context to the jury. And then step four is you get out in front of it and you talk about it before the defense does. So you're not hiding from it. You address it head on. You tell the jury, hey, yeah, this is a weird case because he biked home. He raced 4 days later. He raced 200 times before this trial. Don't you want to find out why? And then you let the rest of the trial be the context that builds it up, builds it up, builds it up, builds it up, until when the defense stands up and gives a closing and says, he raced 200 times, the jury's looking at him like, we know that, but it doesn't mean what you think it does. And then the hammer comes down with the verdict. My name's Taylor Ernst, TBI Lawyer Secrets. Let's all raise the bar and do these cases better going forward. See you next time.